Welcome to Further Comments. I'm so excited to be here. Horace, how are you today?
Damien, I'm doing well. And how are you today?
You know, it's a beautiful sunny day in Minnesota. Spring has sprung. Summer is almost here, so it couldn't be better. I know that you are having some great family time today.
The joys of having two children stay at home because I had a fever yesterday is, you have to experience it to realize how much joy it is.
Joys of parenting. I love it. So there's a lot of knowledge that goes along with parenting. And of course, knowledge management is something that's near and dear to our audiences. So Horace, what are we going to be discussing today?
So Damien, you're alluding to the 30-second intro I gave before we started recording. And that is, in a couple of weeks from now, I'll be giving a seminar for Skills. So for those listeners who don't know what Skills is, it's a yearly, conference, which Oz Benamram and Lucy Dillon, Ron Friedman and others organize. It's the Strategic Knowledge and Innovation Leaders something. Very much big law, KM, innovation folks. They all attend this conference, share knowledge and see what kind of is the cutting edge in the market. So near and dear to my heart, because it's the thing that we do every day at Cynthia. And for listeners who don't know what Cynthia does, you'll know I never talk about it. And so this is kind of like the closest you'll get to knowing what we actually do. But that's the backdrop. I am giving a 1-hour session in a couple of weeks for the summer series of Skills, which is a new thing that's happening this year. And I've entitled my session, Why Your KM Sucks. And that's what we're going to be talking about today.
I love it. Regardless of who you are, that is still true that your KM probably sucks. That seems like an evergreen topic and also ever useful and universal topic. So why exactly does our KM suck?
So in preparation for this, I've interviewed maybe 10 leaders in KM. So Sarah Miro at Sullivan & Cromwell, Phil Bryce at Mayer Brown, Dave Majors and Lauren May at Sidley Austin, and among many others. So if I didn't name you, I'll probably name drop you a little bit later. So we've been interviewing them to understand, okay, what do they think is the state of the market? And relevantly to this podcast, why is it so topical now with the rise of AI? Because that really changes the KM landscape. So where it was, where it is today, and where it's going, and why it sucked before, why it's sucking today, and why it may not suck in the future.
Yeah, this is a great topic because literally just before we started recording, there was a LinkedIn discussion saying, do we even need tagging and curation? Because we just have large language models. You could just throw it into the context window and it'll figure all the things out. There are many reasons why that is a misconception and why it's so prevalent. And hopefully we'll get to be talking about how maybe that is a misconception today.
This whole thing was triggered, and I'll use the word triggered, because for the last couple of months, I've been seeing a lot of claims from CLM vendors and other sort of vendors who claim, hey, you don't need to organize your documents anymore. Just throw these 10,000 documents into a vault, and we are going to be able to get you a first draft of anything you want by prying open that vault and leveraging the past information. And yesterday or the day before, Microsoft even demoed this on stage.
Yes.
Damien, you might have seen. I not jokingly said on LinkedIn, like, dear Microsoft, tell me you haven't been a lawyer without telling me you haven't been a lawyer. Because that was the extent of the demo. And it really irked me. It really irked me because it's an outrageous claim for the fact that you cannot produce anything that's reliable and of a high enough quality with the technology today that would in any way be helpful to lawyers. And I think the problem right now is there's kind of three modes of how knowledge management can interact with this. The first mode is AI replaces knowledge management. So like you said, you no longer need to curate and tag your data. The second mode is AI replaces lawyers, and therefore consumers can go direct to AI. You don't need a lawyer. You don't need a KM team. It can all be done simply by accessing to a database, which is, I think, what Microsoft is pushing in their demo. And the third is AI supplements knowledge work, whether it's helping KM teams, whether it's helping lawyers, it supplements and boosts what they do. Without saying what I think, obviously it's number three. So Damien, what have you seen out there in terms of people making outrageous claims?
That all resonates. And yeah, I looked at that Microsoft, I looked at it askance as you did, saying, really how good is that contract and those provisions that were thrown on stage? And I think that there is a temptation for anyone who is not a subject matter expert to be able to look at what the large language models produces and say, gosh, this is amazing. Like I don't need that subject matter expert anymore. But much like you look at the news and you assume the news is true and correct until you're interviewed issued by a reporter, and then you see the article that comes out, and then you realize, oh, they got all sorts of things wrong in that news article. So there's a paradox, and I don't remember what the name of what I just described that paradox is, but to be able to say that you assume something is correct until you actually become a subject matter expert in it, and then it's not correct at all.
It's not Dunning-Kruger, but it sounds like Dunning-Kruger.
Well, so I mean, yeah, it's a variation. So there's a different name for the news, but yeah, Dunning-Kruger is that if you know very little about something, then you overestimate your knowledge of the thing. And then once you know more about the thing, you realize how little you know about the thing, right? So yeah, so Dunning-Kruger is definitely at play too, and that's a corollary to the news. So really thinking about this, I'm sure the people that created that said, my God, this is amazing. Let's put it up on stage for thousands of people to see. But all the subject matter experts like Horace Wu and all the contract experts say, my God, this would be malpractice if you were to actually put this in front of a client. I think that this really goes to legal tech in general, and then the world society at large, is that large language models are an easy button that everyone is looking for. If you're not a subject matter expert, this is a way that you could be able to unlock what you perceive as subject matter expertise without having to do the hard work of getting the subject matter expertise. And so really think about if you or I or anyone who's listening to this, you use a large language model and you say, here are my symptoms, this medical advice that comes out is amazing. But of course, a physician that is a specialist in that area of medicine would say, my God, look at all the things that are wrong with this, right? So this is kind of Dunning-Kruger a little bit. I think this applies to a lot of startups that are just developer-led. Not lawyer-led, but just developer-led, to be able to say, I don't have any subject matter expertise in legal, but this is an easy button. I don't need subject matter expertise in legal. I just need the large language model and put a little thin abstraction layer on top of it to put a little product on top of it. And then I have an easy button to be able to build any product I'd like without the lawyers that are actually subject matter experts. Does that resonate? Is that a good way to frame it?
I think that's absolutely right. Some of those startups have gotten a lot of funding. Some of those have not. Who knows why they get funding and why they do not. But all that said, I think there are some startups who are not lawyer-led or lawyer-founded that have been successful, that are really good at what they do. And I think they are that way because they listen to their customers.
And once you are building this, you're listening to your customers, you're giving them easy buttons light, we'll call it LITE, light, easy buttons that incorporate their subject matter expertise. Then you have to say, okay, for whom is the product being built? Is it being built for lawyers? Or is it being built for consumers? Is it in-house counsel, et cetera? And not just in-house counsel, but maybe business people within the business unit of the corporation.
Lots of little personas, shades of gray across all.
That's right. And so then you have to say, okay, there's a spectrum between perfect tool and then a good enough tool. And the question is what is the value of the perfect versus the good enough? What is the delta between those two? And what is a client and customer willing to pay for? And the real question is what Microsoft showed on screen at that Microsoft Build conference. Certainly it's not perfect, not even good, right? If you ask any contract lawyer. But the question is it good enough to the small and medium businesses that are out there that can't afford Horace Wu? Or they can't afford the big lawyers that are out there. Is it good enough for the consumer that's just a solo small business, right? I can't afford a lawyer anyway. I crank something out with this Microsoft tool that maybe is good enough and is better than plain old Googling, which is the alternative before. So anytime in data science, you have to say compared to what? And compared with the existing tool that the small and medium business has, the existing tool being Google, this is far, far better than that existing tool. What do you think of good enough?
I think you've nailed exactly the market that Microsoft is going after. They're trying to say, hey, if you didn't previously have access to a lawyer because of cost, because of anything else, here is a substitute. It's a first step, and we're going to recognize it as the first step. Not today's tool, but in some future state, it will be able to make do. You can then leverage that. You can then use it in your everyday life. Now, the danger, of course, is legal contracts have consequences. And I think this is where there's a massive missing hole in the market at the moment. And it's tools that help with verification of correctness. I don't see that category around at the moment. I think that's going to become a more and more pressing need as more of these AI tools become prevalent, become used, kind of like in the developers world, where developers are very different. Like when you use AI to generate code, it's very easy to hit the button that says run, and it either works or it doesn't work. For lawyers, however, and legal documents, you don't have that luxury. You can't just go, hey, run it, see what's going to happen. The courts can tell you, but that comes with consequences. So that gap of verification tools, I think someone, somewhere, maybe me, will then create something to fill that gap.
That's right. Laws without teeth. that is without enforcement are really useless. That is, if we have a law against jaywalking and it's never enforced, who cares about that law against jaywalking, right? The law is only as good as its enforcement. So in the same way, a contract is only as good as its enforcement. So if I am a solo small, the business owner, that is going to do a contract that is next to zero chance of being enforced, that is to be litigated against, what's the point, right? Because really all that contract is doing is mitigating legal risk. And if there is really next to no legal risk on there being a dispute over this contract, is the risk that I'm avoiding by writing this perfectly drafted contract, is that risk so small because I'm not going to sue over this thing anyway, because litigation is super expensive. Right. So really, this goes back to Alex Hamilton, who you probably know, that is a good friend.
Yes.
And I really love Alex. And his point is that contracts are all about the relationship. The point is not the piece of paper that we're doing, but the piece of paper reflects your and my relationship. And if that piece of paper essentially strengthens our relationship and allows us to go forward meaningfully, then that piece of paper has done its job. So in the same way, or a similar way, maybe if the Microsoft piece of paper that maybe is good enough, that isn't as good as the top 20 law firm in the world, but is good enough to be able to bolster our relationship. And if our contract is not going to be disputed because litigation is too expensive for me or you to go into anyway, maybe that good enough is truly good enough. So that's point number one. Point number two is, what if litigation shrinks in cost? That is, what if the tools I'm making and others are making make litigation so cheap that maybe what I've said with number one maybe is not true anymore, right? That maybe we will get in more disputes, more contract disputes, because the cost of litigation is so cheap that, let's go ahead and throw it to the courts and see what they think. What do you think of either of those points?
Well, okay, so on your second point first, and you triggered this really interesting idea. Rather than building verification tools, what if we built private robo-judges that are able to look at all the circumstances and say, hey, here's the predicted outcome. So it doesn't help the lawyer verify the content and make it more correct, but instead it warns you as to the consequences so you can decide whether or not to proceed. Interesting alternative way to decide how to proceed. But back to your first point. I agree with you and Alex that yes, contracts are there to build a relationship. Contracts are there to formalize the relationship. What I was taught is nobody needs a contract when things are going well. I mean, you shake hands, you change terms, so it's all okay. Where contracts come into play is when things turn to shit. And that's where you want to look at the exact words and go, oh crap, am I covered? The number of calls I used to get when I was practicing, where someone's like, so this just happened, what do we do? And then you read the contract and go, oh, F word, we never thought about that. That's why the contracts are there. And that's why litigators are there. So yes, it's for relationships, but also, yes, it's to cover your ass.
Exactly. And how much of legal work is covering your ass? And I say that all of it is, because really everything that a lawyer does is mitigating risk or providing advice on creating business value. Either one of those two, either mitigating the risk or providing additional value that wasn't there before. One of my smartest mentors, after I stopped practicing law and started in the business side of things, he said that if you're starting to talk litigation, you've already lost. That is, you've lost the relationship, right? So, I mean, that once you talk about, well, I'm going to enforce this contract provision, right? I mean, you may win that battle, but you've lost the war, because really the whole point is to do business, is not to litigate every small thing. So that's thing number one, is are we building our contracts to be able to win the war and not just win the skirmishes of the battles? Thing number two is to your really good point about maybe a bot can be able to decide these things. There's actually already, there's binding arbitration, and now there's also literally in the world binding bot arbitration, where Arbitration.ai, you may have heard, has a way that you and I in a contract can say, we agree to be bound by Arbitration.ai. And then if we're in a dispute, you and I, you upload your documents, your emails, your kind of things, of correspondence, I upload my documents. 20 seconds later, Arbitration.ai provides a response saying Horace is likely to win. So then you and I move on with our relationship. Right? No litigators involved, no one, and we agree to these things. So that is Arbitration.ai. Also, the American Arbitration Association is looking to do such things. Bridget McCormick, who's doing brilliant things as head of the AAA, and if you don't know Bridget, you should. She is a former Supreme Court justice for the Michigan Supreme Court, and she is really building binding bot arbitration too, to be able to help access to justice. To help, if you have a dispute, you and I are in a dispute less than $75,000, it's not worth any lawyer's time to be able to do those things. And it's not with my expense. If I'm spending more than $75,000 in litigation fees, what's the point? So she's really seeing this as an access to justice issue, to be able to say, let's push that $75,000 less so that we can actually have these smaller disputes be resolvable in a way that they aren't today. And $75,000, it's not a crazy amount of money, but to most of the people out there, that's the question of whether you have a home over your head or whether your business survives or not survives. So this is a true access to justice issue, and having binding bot arbitration is not just something that the world needs, but I think that we should demand to be able to have access to justice.
I didn't realize it had already advanced so far. I mean, that's phenomenal advancement. This conversation that we're having right now about how AI affects lawyers, how AI is going to help access to justice and order. We touched that topic a lot. We're talking about the impact on lawyers, but what about the impact of AI on those people that support lawyers, the support staff? If you look at a Venn diagram of how AI impacts the business of law and the practice of law, touching the actual practice that lawyers do is maybe a quarter of the overall impact of AI. Touching the librarians, the KM staff, touching the sort of paralegals and the work that they do. The business of law, looking at billing, looking at metadata, looking at forecasting, RFPs, all of that. We rarely ever talk about that, but I think that's going to end up being a bigger impact on the state of law firms as a business and to the practices of law that lawyers are going to engage in going forward. Because I think the threshold for acceptability of AI is a lot lower for those types of work where it doesn't directly go out to clients. And I think we're seeing the impact of that already. I don't think we talk about that enough.
I think that's right. You just talked about three personas: helpful to lawyers, number one; helpful to lawyer support staff, number two; and also helpful to consumers, number three. The threshold for how perfect it needs to be is different for all three of those. And this goes actually to our previous episode where we talked about QA. The junior associate does a thing, the senior associate looks over the thing, and then the junior partner looks over the thing, and then the senior partner looks over the thing, and then it goes out the door, right? So if you have 4 levels of QA, the amount of perfect it needs to be is probably less important for the lawyer side, maybe more important for the consumer side. If it's going to come out of the machine and go directly to the judge, you really need that level of precision and recall, accuracy, to be very, very high. And of course, very, very high in the context of compared to what, right? So really, right now, Googling something and asking for it to be able to draft a motion to dismiss for breach of contract, Googling the precision and recall accuracy is horrible, just using plain old Google. Right? ChatGPT is going to be a bit better, where ChatGPT might give you law for California, even though you're sitting in New York, right? So it's going to be better, but it still might be a lot of error. But if you have a built for purpose tool that is for a consumer to be able to say, the tool says, well, where are you located? Well, I'm located in New York. Okay, cool. Was there a contract? Yes. Where was the choice of law provision in that contract? Well, that choice of law is California. Then if the system were to say, okay, here's the law for California and here's the law for New York, and based on what your facts are, you've satisfied the law in California, but you've not satisfied the law in New York. So maybe you want to apply New York law instead of California law, right? So if you have a system that does that kind of dialogue in the same way that a human would do that dialogue with their client, then that rate of precision of recall, the accuracy, is going to be much, much higher. Really, so now, helpful to whom? Helpful to consumers, you definitely need that level of back and forth to be able to walk the consumer down the primrose path of what needs to be asked. Helpful to support staff, they'll know a lot of these things, so they don't need to be walked down the primrose path as much. And then helpful to lawyers, right? They'll already know intuitively all those questions to be asked, and so maybe you don't need to be that helpful to them. So I think the precision and recall, the accuracy of the system really needs to focus on consumers versus support staff versus lawyers, and each of those personas has to tune their accuracy, precision accordingly.
And I think there's actually the inverse sort of requirement where for lawyers who already know what they do, they don't want a chatbot. They just want to go, I just want the answer. You know what I want, just give me that page with the answer on it. So the design philosophy and how it should be presented is going to be entirely different as well. Traditionally, and I'll tie it back to the whole why your KM sucks topic that started this conversation. Traditionally, a lot of times KM teams are there to fill that gap where lawyers are like, I need this information, and the KM staff would then go and find that information, present it to the lawyers. Phil Bryce put it really nicely to say, look, it's like that. I don't know if you've seen the meme a while back where there's like dots on a page and you can draw lines between them. And so it graduates from data to information to insights to wisdom. that's sort of like the spectrum of needs that lawyers have. But you don't know in advance what lawyers want which level of need. Some people just want the answer. So give me the wisdom, KM team. Very rarely. Most lawyers are asking for, give me all the evidence so that I can apply my wisdom to the information. Very rarely do lawyers go, give me all the scattered data with no organization and let me go and solve all of that myself. So like traditionally, KM teams have had to juggle between the delivery of the sophistication of information or sophistication of knowledge. And I think with AI, one of the use cases for AI that I think is understated at the moment. Again, we're looking for gaps in the market. So Y Combinator, anyone else listening, here are opportunities for you to build stuff. One of the gaps that I think AI can apply to is if someone is able to create the information in a structured manner, not just the data, not just a scattered database, then use AI to transform that into the different types of requirements that the end users have. So the AI becomes that final layer to bridge the gap that KM teams don't have time to do, because KM teams are collecting, curating, managing all of that. They don't then want to rewrite every time someone says, no, can you just frame it this way for me? They're not research report writers. So there's a use case there.
I think that's right. Just give me the answers, right? And that's a knowledge management goal, is to be able to just give you the answers in a well-structured, curated way, to be able to say, this is the law in this area, therefore the answer is X, Y, and Z. To be able to get to that endpoint, you need to be able to answer the question that is asked of every lawyer, tell me about the law on this, and every lawyer will say, well, it depends. And then every time I received that answer from a lawyer, I would say, it depends on what? And then the lawyer would say X, Y, and Z, and then I would add X, Y, and Z to SALI for the 5 years that I helped lead SALI. So you can taxonomically tag, it depends. That is, what makes the deal move this way or that way? It depends. Count that. What makes the litigation move this way or that way? It depends. Count that. Tag up all those things on the litigation and transactional side. And of course, SALI has 18,000 of the it depends. We've been collecting, SALI was collecting them since 2017. They started. I was there from 2020 to 25 for about 5 years. And now FOLIO is continuing to collect the it depends. It depends really focuses on, number one is the statutes. It depends on the cases, how the cases have interpreted that statutes, regulations. And number three is just practice during the negotiation, whether it's a negotiation on the transactional side or during the negotiation of the settlement agreement. What happens in the closed room negotiation that pushes the needle left and right. So really, we're collecting all three of those things. The statutory, it depends, the case law, it depends, and then the practice of law, the stuff that is stuck in lawyers' brains, that is not an artifact.
The tacit
knowledge. Right.
Yes.
FOLIO is collecting all of those things. And the way that we're doing that, SALI, think of that like a top-down way to be able to say, we collected from Phil Bryce of Mayor Brown. He gave me his taxonomy of over 1,300 taxonomical items that I essentially mapped and said, SALI already has a whole bunch of these things, but SALI was actually missing a bunch of the other things. And so we took Mayor Brown's top-down ontology, extracted the Frankenstein kind of topics into its component parts, and then put those into SALI. I did that in 2024. So this top-down ontology from the biggest law firms in the world, from the biggest technology companies in the world, from the biggest clients in the world, that is SALI as a top-down. And what FOLIO is doing is now doing a bottom-up analysis. So Mike Bomarito, who listeners probably know, he's one of the guys along with Dan Katz and Pablo Redondo who beat the bar exam using GPT-4. He is one of the smartest guys in legal tech. What he's done is to take the entire United States code and done a bottom-up analysis, saying, you are an expert ontologist, extract all of the it depends from the US code. And all the taxonomical items from the US code. And it then extracts them along with the relationships between those taxonomical items. And so what we're doing is we're merging that bottom-up ontology with SALI FOLIO's top-down ontology from the knowledge from the brains to fill in the gaps, find more it depends. Once you do those things, then that really gives you more of an easy button that we've been talking about during this talk, because now I've been collecting all of the it depends, so you can essentially create an expert system to say, well, if it's this way, then this is the path. If it's that way, though, this is the other path. And that really depends on legal research. That is, what does the case say? New York law, it goes this way. California law, it goes that way. So really, you need to collect all of the it depends in a knowledge management. You need to tag up all of the items so you can create that expert system. Is that why people's KM sucks and maybe ways to get out of the KM sucking?
So I think I'm going to call this episode the easy button or variation of that, because I think you've hit the nail on the head. People expect this to be easy. Why haven't you already organized all of our knowledge from the database of millions and millions of documents in our DMS into something that's structured that I can just press a single button to retrieve? And the answer is because they haven't had 30 years of human resource to do this, and they don't have the time and the budget and the costs, etc. And so the easy button doesn't exist. You have to put in the hard work.
But how hard with large language models? Is it making it easier?
No. Okay, so I'm going to reveal one of the theses from the presentation I'll be doing, and that is right now there's a lot of time and investment being put into using large language models to run over existing collections of data, to tag it up, whether it's SALI or a custom model or FOLIO or any sort of like of these taxonomies, but to tag it up so that you can search and retrieve them easier. Centauri is doing that. Foundation Dragon is doing that. I'm sure others are doing that as well. I think that's a very worthwhile effort. However, that's not fixing the problem. The problem is you're not collecting the right data in the first place. And unless you design systems, unless you design ways to both, one, be able to collect data, and two, incentivize users to volunteer the data. And I think this is going back to your point, Damien, of when you ask lawyers, it depends, you're assuming they're answering your question. They can just simply never reply and ghost you. And if they do that, then you never get an answer and you can never have a taxonomy. So how do we design systems that are able to capture the right data? How do we incentivize users to want to volunteer extra information and context? Those are missing things that unless we solve for, KM is going to continue to suck because you're patching up things from the past.
And that goes to something that in the last week I posted a LinkedIn post that touches on exactly what you're talking about, is that there's the stuff that's in the document management system, contracts, briefs, pleadings, motions, etc. So that's in the DMS. So that's some knowledge. But there's a lot of knowledge stuck in people's brains that is not yet in the knowledge management system. What is the value of those things? And how do you get the users to move it from their brains into some sort of artifact, whether it's a knowledge management system or the document management system, to be able to say now it's an artifact that could be used by a large language model or others, or even a good old-fashioned AI to be able to filter all of the it depends to be able to get the right answer. So moving it from the human lawyer's brain into the system as an artifact is historically time-consuming. In addition to time-consuming, I'm providing value to my organization. If I'm transferring value from my brain into my organization, what is the monetary value of that? Because if I'm a law firm that is working right now for law firm number one, but I'm thinking about jumping ship to law firm number two, am I going to want to dump all of the knowledge in my brain, which is the currency of the realm these days, right before I jump ship to law firm number two? And if I'm not really beholden to law firm number one, why would I give that value without monetary compensation for such things?
You've addressed a really hard human question, which is why I think these systems have to be invisible. You have to be able to capture that data as people are working without them feeling like they're giving away the farm. So very difficult thing to design for. I think it's possible, of course, but you have to really understand transformation. You have to really understand humanity. And I think for the knowledge management team and the lawyers in particular, you have to really understand the problem you're trying to solve, because the problem you're trying to solve defines what data you want to collect or scrape or extract, and then how to apply AI to it.
Yeah, this applies to a term that your users may have heard of, maybe not, called data exhaust. That is, as I'm doing my work, there's just data exhaust that's coming out, and then you could actually be able to utilize that data exhaust to be able to do knowledge managed work. So the classic example of data exhaust is the documents that are created in the terms of a deal, or the documents created in the terms of litigation, right? These are all data exhaust that I didn't really mean to, but all of a sudden this is a treasure trove of data in the document DMS. That's number one. But there's a whole lot of data exhaust that's not being captured right now in the form of discussions. In fact, you and I are having a discussion right now that is currently being transcribed as a discussion. This is data exhaust. I'd like to think, providing lots of nuggets of gold to our listeners. And those nuggets of gold,
yes,
right? If we had just been at a conference somewhere, that would go off into ether, never to be captured. So that data exhaust would go into the atmosphere and contributing to the CO2 levels in our atmosphere, right? But now we can actually capture that data exhaust in the form of a transcript that can be put into an artifact where we can use large language models to extract all of the it depends from our discussion, tag those things up. And then this is now a very helpful for retrieval augmented generation to do these discussions. And this is something that, as we think about the forms of oil, public oil and private oil that we've talked about, oral discussions are a very valuable source of oil that are being thrown into the atmosphere as data exhaust, but should be captured. Otter AI's CEO was telling a story that I heard where he said that because Otter AI records Zoom calls and that kind of things, they, of course, internally within the company record every single meeting that they have, and they transcribe every single meeting they have. And so what the Otter AI CEO does is, at an all-hands meeting, if he says, okay, these are the 3 goals that we as a company need to be able to follow, he can then go through the transcripts of all the meetings of all the subordinates. And then if they fail to further goal number 2 consistently, he'll go to that manager and say, hey, why aren't you emphasizing goal number 2? You need to emphasize goal number 2 more. He can only do that big brother-ish thing, by the way. This is maybe the dystopia that we deserve, but maybe don't want. But anyway, big brother, yes. But also from an organizational perspective, if you want everyone rowing in the same direction, this is a way to capture that data exhaust in a way that's truly helpful if he wants all 3 goals to be achieved. Now, take it away from Otter AI, but go to client discussions. So as you're having a client discussion, if you can get comfortable with the fact that I record it will not breach attorney-client privilege, right? If you can get over that hurdle, then if I record every single conversation with the client, that will be a good source of data exhaust for me to be able to extract all of the it depends. Not just all of the it depends from a legal perspective. The statute requires this, the regulation requires this, the case requires this, but also from a practical perspective. Because the clients will say, well, it depends. If I do this, I'm going to fail tomorrow because all of my revenue will go away, right? That is it depends that really will affect the legal advice. So this form of data exhaust in the form of recordings is something that I think we haven't even touched on, but is going to be a huge source of revenue.
So speaking practically about recordings, and you gave so many nuggets just now that I can only pick up a few, but speaking on recordings specifically, one of the issues with transcribing recordings like this one is every one of these conversations tend to be talking about a very small facet of a very large thing. And therefore, even if you were to record every single conversation that happens between us, which, by the way, we seem to do these days, you still need some way of organizing the information to structure it so that you pick up the relevant pieces to form that bigger picture. Because at the moment, very, very few models can handle a large context window like this, and very few models can handle large context windows with enough precision and accuracy. One day, maybe, if you draw a sort of diagram, and I'm giving away another nugget here, but if you draw another diagram where the horizontal x-axis is how intelligent these models are getting over time, and GPT 3.5, 4, 4.5, soon GPT 5, maybe, they're getting smarter and smarter, but that's on a single dimension. These models don't know anything about you, don't know anything about your circumstances, your context, and that's the y-axis, where as you capture more, as you're able to retrieve the right parts of this to feed into the model, that y-axis is what I think a lot of organizations, law firms, KM, etc., should be working on, because this is the competitive edge. Leave the building of the smart machines to you, Damien, to maybe me, but the capture of the information, the utilization of the information, that is the competitive edge the organization should be working on.
That's right. And the question is how soon before those context windows will get bigger. I was just watching Sequoia, I think, interviewed one of Google's engineers that it really is focused on doing the cutting edge Gemini models that are coming out. And he was the guy who decided back when context windows maxed out at 128K, he was the guy within Google that said, let's not just go to like 256 or something like that. Let's go to 1 million. Because, 2x is not nearly as cool as 10x, right? Let's do 10x, and then that's going to knock the socks off people. So Google's Gemini has a 1 million token context window. It's had that for now about a year. He said, now the next context window we're going to do is 10 million. Imagine if we have a 10 million token context window, and it looks like they're building it right now, and they should be releasing it quite soon. The question, of course, all the engineers are going to say, okay, but needle in the haystack test, right? Is it going to be really able to really pluck out the thing I need from that massive 10 million context window? And for those who don't know what 10 million tokens looks like, think like the entire Lord of the Rings trilogy, plus maybe the Harry Potter series, then plus some, that's about 10 million, right? Any deal or any litigation probably will fit, at least the hot docs of that, will fit within that 10 million context window. So if you can now reason with the entirety of a litigation or entirety of a deal, that's what 10 million tokens looks like. So anyway, so you might say, okay, well then if I have 10 million tokens, why do I even need to tag up or structure the data? Because it'll just be all be within my context window. That's the temptation. But the reason that you want that is to have, number one, higher quality, and number two, cost effectiveness. The higher quality side is that if you tag things up, then you could be able to say that motion to dismiss is always called a motion to dismiss, unless you're in California when it's called a demurrer. So if you build up symbolic tagging, you will say that the concept of motion to dismiss and the concept of demurrer is the same. Therefore, we're going to tag up demurrers and tag up motions to dismiss the same. So my retrieval augmented generation, my RAG, will be higher quality because I've now tagged up the proper tag with motion to dismiss / demurrer. And in this way, you'll be able to capture and you'll be able to avoid the false negatives of missing demurrers when you search for motions to dismiss, right? So number one, better RAG equals higher quality. Number two is better RAG equals cheaper. That is, if you have knowledge management, now you don't have to use the entire context window of 10 million tokens. You could be able to say, okay, I've filtered to only the motions to dismiss and the demurrers that matter. And now I'm paying less money to Google. I'm paying less money to OpenAI. I'm paying less money to Piper. And now I can do things more cost effectively. So why do you need smart knowledge management in the age of large context windows? Number one, higher quality. Number two, cheaper because you're running fewer tokens.
I'm going to add two more to that. And the third is quality control, because you are ensuring for verification purposes, you're already looking at the right things. Whenever a language model produces an output, and I've said this in other contexts, but every single word it's producing is a hallucination. It just happens to get it right sometimes. So you need to, as you say, Damien, trust but verify. And that verification exercise needs quality content, which means you need to find that content. So that's number 3 on the list. Number 4 on the list is it saves you time. The one thing that this is all trying to solve for is the limitation of time and the constraints that we all have to be able to do all the work that we need to do to address the justice gap, to be able to deliver high outputs in the same amount of time. All of the work to prepare the data, to organize the data, all of that is aiming for high quality, less time, cheaper for everybody.
That's right. And time, not only at runtime, that is, once I ask the query, I want to be able to save time at runtime, but also the pre-processing step. To be able to tag up all these documents and summarize all the documents historically has taken forever. Right? And it takes so much time that nobody's taken the time to tag up their document as they upload it to their document management system. They haven't taken the time to be able to summarize that document going up because it's just taken so much effort. So that was the old world. But the new world is as soon as the document gets produced, that data exhaust can be tagged up programmatically. That is, FOLIO is building a way that you upload a document and we will be able to classify the document as a motion to dismiss or a demurrer, or classify the document as a merger agreement. So tag up the document type programmatically, and then also tag up the contents programmatically. That is, to be able to say this motion to dismiss mentions breach of contract or patent infringement, or this merger agreement mentions force majeure clauses, etc. So be able to tag them up. So yes, a tag up time at runtime, that is the time when I as a user am actually using the system, but also saving a lot of time that would have been otherwise utilized in tagging up and classifying the document.
So all that work that we and the KM team and everyone else is doing, that's so that the end users can have an easy button.
That's right. And hopefully in our new world, you, Horace, me, Damien, and FOLIO are building a way to say that the human effort in the new world to create that stitch in time that will save 9 for the end user, the amount of time to be able to classify the documents in a well-structured way is going to shrink. And I can almost hear Alex Smith in the background saying, but Damien, what is your precision? What is your recall? on that document classification. I can just hear him. And Alex is one of my favorite people in the world. He has IA before AI every day of the week.
AI before AI.
Man,
Yep.
I that burned into my memory 5 years ago, and it will never go away. So to Alex and everyone thinking like Alex, okay, what is the precision and what is the recall? I go back to compared to what? And compared to the old world, where option one is for me as a human to tag up this thing as I upload it to my DMS, or I as a human to summarize this thing as it goes in here, compared to that, it's going to be way better because that thing didn't actually happen, right? So compared to the old world, what FOLIO is building is going to be better than that. I'm sure what Alex is building and what you, Horace, are building and others are going to be even higher precision and higher recall. And if so, awesome, right? But the real question is, what is the value of that additional delta between what FOLIO builds and what the other vendors build? I think that what FOLIO is doing is kind of raising the bar of that value. You as a commercial vendor better be doing more than what the nonprofit, that is ALIA is a 501c3 nonprofit, that is giving away FOLIO and all of its tools. You better do a lot better than free to be able to compete in this marketplace.
Absolutely. Our usual question to end this is what's making you optimistic? And I'm going to answer that preemptively by saying what's making me optimistic right now is everything that's been open sourced. So you may or may not have seen Microsoft open sourced this week, one, their Windows to Linux thing, which I know very little about, but my engineers are very excited about. And two, they open sourced, I think VS Code. No, VS Code was always open sourced.
But yeah, the ability to be able to do agentic things on top of VS Code.
Yes, they did. They open source Copilot, which is incredible because now everyone can build on top of it. We rarely see that in legal. But if Microsoft is getting into legal, like we're talking about in the beginning, and they're open sourcing, then I think more and more of that's going to happen. And I think all of us are going to improve on this quality curve.
Yeah. So usually we have different things that we're optimistic about, but open source is so important that I'm going to join you in my optimism about open source. I'm fresh off a meeting with Mike Bomarito where we talked about all the FOLIO things that we're going to be open sourcing. And we're essentially creating a roadmap of being able to open source all the tools I've talked about during this podcast and other tools that I haven't yet talked about. Like, for example, a mapping tool. If you as a vendor or you as a law firm or you as a corporation have a taxonomy like Mayor Brown did, you can upload that Excel spreadsheet and be able to map that to what SALI/FOLIO, all of those tags programmatically, something that would take me a month to do for Mayor Brown, which it took me a month to do those 1,300 things. What took a month now takes minutes. For that to be free and open source is a modern miracle that is enabled by large language models and brilliant people like Mike Bomarito. So I'm optimistic about open source. If those things become free, as you say, everybody can build upon them. Microsoft open source their thing, everyone can build upon it. FOLIO is open sourcing all of their things, everyone can build upon it, whether you're a corporation or a legal tech vendor or a law firm. That rising tide will float everyone's boats.
One day we should invite John Scordato on this podcast
100%.
because he has a very passionate view on
this. That's right. And this is better for humanity. Open source is trying to have good people like John Scordato and good people like Mike Bomarito essentially make the world better by donating their time to be able to help the whole of humanity. And I agree. We should definitely have John Scordato on.
Well, with that, John, if you're listening, you're going to be up after our next guest, which is Dr. Megan Ma.
I'm so excited. Megan is, if you don't know Megan, you should. One of the smartest people in technology, and she's at Stanford doing amazing things. She is going to be a fantastic guest.
Oh, I'm looking forward to it. Damien, I hope you're doing well, and you're going to, I know you're traveling next week, so be safe.
Yeah, Eastern Europe I come. I'm going to be in Tallinn, Estonia. They said, will you speak in Tallinn? And I said, if you tell me where Tallinn is on the map, I'm happy to go there.
I look forward to hearing your stories when you're back. And listeners, thank you for joining us once again.
Thank you, Horace. You come up with the best ideas, and I'm really grateful that we're co-pilots on these things. So thank you to our listeners, and I hope you have a great rest of your day, week, month.
Nothing but love from us.
All right. Thanks, everyone.
Bye.